Pia Justesen is a human rights lawyer, a Danish human rights lawyer currently living in Chicago, where she teaches disability rights at the University of Illinois and works with an independent living organisation, Access Living. She also has a new book coming out, which is a series of oral histories looking in particular at questions around disability rights, and she's engaged extensively on questions relating to the rights of persons with disabilities and also people living in racial minorities. And our second panellist is my colleague from the Irish Centre for Human Rights here at School of Law, NUIG Galway, Dr. Maeve O'Rourke. Maeve is a barrister with many years legal practice experience and also an academic working in particular on questions relating to institutional abuse, with a particular focus on the gender dimensions of institutional abuse, and also the rights of older persons. And Maeve has a long history of advocacy working with the UN Committee Against Torture in particular, and other UN human rights treaty bodies, as well as the Special Rapporteur on Torture, and more recently working in the domestic context in submissions to the Commission on mother and baby homes, and also advocating in relation to institutional abuse in so-called Magdalene laundries. So delighted to welcome both of our panellists. Pia? Thank you.
So thank you very much for the kind introduction. And I want to excuse that, or apologize for self-promoting this book, but I'm very, I'm just really proud of all these stories, all these oral narratives that I've collected here, not because I've collected them, but because of all the powerful, empowered voices there. And many of the people that I interviewed for this book talked about family and the importance of family life. And I want to just start with one of the individuals that I spoke to. This is Candice Coleman. She has cerebral palsy, and she tells me, "My family is very family-centered. We take care of one another. We do a lot of things together. They never allowed me to think about my disability first. Like, you can do whatever you want to do. You just have to deal with some things. So I grew up not knowing that I had a disability. It wasn't until I had to deal with outside people who would look at me or point at me. So what I will do here now is to provide, that's at least my aim, to provide a general overview of the international human right to family life. This is a big topic, and it's a lot to cover in 20 minutes, but I'll still try to do that. And I'll start with the international general human rights, and then we'll look at the CRPD a little bit later. So when we look at the various international instruments that are relevant when we talk about human rights, I think it's important to underline that these instruments apply to all human beings. Obviously, that means that they also apply to people with disabilities, as well as anybody else. I think it continues to be important to stress that, and which is very obvious, that people with disabilities have the same human rights as everybody else. So that's why I want to start with these in general international instruments. What do they say about family life? Let's start with the Universal Declaration of Human Rights. As we already talked about, this is an old declaration. It's from '48, and it does establish the right to marry and to found a family in its Article 16. It also establishes that the states have to protect the family. This is a soft law instrument, so it's not legally binding in the member states or in the states. But we have, fortunately, the manifestations of these legal rights in later conventions. And we have that in the International Covenant of Civil and Political Rights from 1966, which in Article 23 establishes as a legal right the right to marry, the right to found a family, and that the states must protect the family. The committee that oversees the ICCPR has made two general comments that are relevant. It's General Comment 16 and it's General Comment 19. The most important thing of General Comment 16 for what we are talking about this week is really that the concept of family must be interpreted broadly. So it's not just something that we feel is important, it's actually established in a General Comment. General Comment 19 from 1990, again, talks about protection of the family, but it also talks about the right to marriage and the equality of spouses. The next relevant convention that we have is the International Covenant of Economic, Social, and Cultural Rights, which again establishes the right to marry and found a family in its Article 10. The committee that oversees this convention has also adopted a general comment which is relevant for what we talk about today, and that's General Comment number 5, which is focusing in particular on people with disabilities. This general comment is from 1944, and it establishes that persons with disabilities have the right to marry and have their own family. And again, family needs to be interpreted broadly. It states that sterilization and abortion without previous informed consent are serious human rights violations. So again, we have that in a general comment. The next convention that's relevant is the CDLP Convention, the Convention on the Elimination of Discrimination Against Women. This is a convention that establishes, again, a right to marry, but also a right to decide on the number of children that one wants to have and the space between those children. And those of you who know Article 23 of the CRPD will recognize this language. So you can sort of see when we go into Article 23 of the CRPD that it takes a lot of language from all these other human rights conventions. We have a case for the CDLP committee that's relevant when we talk about the right to family life, and this is the case Chateau, I believe it's pronounced, versus Hungary from 2006. This was a case about a Roma woman who had some complications while giving childbirth. And during that, she had surgery and she was sterilized. She hadn't consented to that prior to the surgery. She actually didn't know it was going to happen. So she complained to the CDLP committee, and the committee found that this surgery infringed on her right to decide on the number and the spacing of children, and this was a serious human rights violation. So let's look at regional instruments that are also relevant here when we talk about the right to family life. We have the African Charter on Human and People's Rights from '81, which establishes that the family shall be the natural unit and basis of society, and that it shall be protected by the state. It also says that the states have the duty to assist families. We have the American Convention on Human Rights, Article 17, which states that the family is the natural and fundamental group unit in society and is entitled to protection by the state. And then we have the European Convention on Human Rights, which has two articles that are relevant for the right to family life. Article 8, respect for private and family life. And Article 8 says that the state cannot interfere in this right unless there are some certain situations, which, for example, could be the respect of other people's rights. Article 12 of the European Convention for Human Rights talks about the right to marry and to found a family. The European Court of Human Rights is probably the international human rights body that has the most case law when it comes to the right to family life. And so there are many cases to be inspired from and to look into. But one case I want to mention here is the case of Kutzner versus Germany. This case dealt with the forced removal of 2 children from their parents. Both parents had psychosocial disabilities. The court in this case stated that the mutual enjoyment by parent and child of each other's company constitutes a fundamental element of family life. So the removal of the children into foster care constituted an interference in this right to respect for family life. So the question for the court, therefore, was whether this interference was justified. The court said that there was no doubt that the forced removal was in accordance with the law. The court also said that the aim of the removal was legitimate because it was intended to protect the children. But the court found that the removal was unnecessary. It was not proportionate to the legitimate aim that the government had pursued. The court argued that the government of Germany had not considered additional measures to support the parents as an alternative to this most, you can say, extreme measure, which was to separate the children from the parents. And the court also argued that the removal in principle should be regarded as a temporary measure. So it had to be discontinued as soon as circumstances allowed. So the court concluded that Article 8 of the European Convention of Human Rights had been violated. And I think the case is important because it illustrates that although we think of the European Convention of Human Rights to traditionally only protect civil and political rights, in this case the court finds that the effective respect of family life also encompasses some positive obligations on the member states, like making sure and taking concrete actions that parents and children who have been separated will be united again. So let's sum up the general human right to family life. It's a right to marry, it's a right to have equal rights with your spouse, it's a right to exercise your sexuality, it's a right to found a family, it's a right to decide on the number and spacing of children, it's the right to adopt and to be guardians, and it's the right to be reunited if you have been separated. That was the general human rights that are rights for all human beings, including people with disabilities. And then we have the CRPD, which more concretely and more elaborately explains what the right to family life means for people with disabilities. And if you haven't done so already, I really encourage you to read the article in full because it really describes very well what the right to family life actually is all about. So the first section of Article 23 is about stopping discrimination when it comes to marriage and family life. It's about the right to marry and to decide on children, how many you want to have, the space between them. It's about retaining fertility. The next sections of Article 23, and I'm just going to go through this very quickly. It's about the right to be a guardian and adopt and be adoptive parents. It's also about if you are a parent with a disability, if you need some kind of assistance to rear your children, then you actually have a right to get this assistance from the government. It's about the rights of children with disabilities. It's about protecting the best interest of the child. It's about prevention of sending children with disabilities into institutional settings. So in general, when we look at the obligations of member states, according to the CRPD, We talk about the obligation to respect, the obligation to protect, and the obligation to fulfill. The obligation to respect means that the states must refrain from any act that's inconsistent with the CRPD. For example, if there are laws that prohibits people with disabilities from marrying or being parents, such laws must be repealed. The second obligation to protect is really about preventing violations of the right to family life by private sector. So that could be other individuals, institutions, corporations. It, for example, means that if there are private nursing homes, the state is obligated to monitor the conditions in these private nursing homes to secure that the right to family life is enforced. And then the last obligation is the obligation to fulfill, which is often the most complex obligation you can say, because that means that states must take whatever appropriate legislative, administrative, financial measures to make sure that these rights are actually realized. For example, states are obligated to support parents with disabilities if they need such support and assistance to rear their children. So let me talk about the CRPD Committee on the Right to Family Life. The committee has not yet adopted a general comment on the right to family life, but there is one general comment on women and girls with disabilities that's relevant here. It talks about all the barriers that there are to the right to family life for women. And it also provides some recommendations as to what can be done. But let me finish with one case for the CRPD committee that I think is relevant. This is the only case that the committee has considered on the merits on the right to family life on Article 23, and it's a very recent case from December last year, and it's against my home country, Denmark. So the case dealt with Ms. Domina from Ukraine and Mr. Benson from Denmark. They are married. They got married in 2013, and they have a son who was born in 2015. And Mr. Benson has a brain damage, which is a result from a serious car accident in 2009. So they were rejected family reunification when they applied for it. And they filed a complaint to the CRPD committee claiming that they were discriminated against based on Mr. Benson's disability. So according to the Danish Aliens Act, a residence permit based on a family reunification cannot be granted if the applicant's spouse has received social benefits in a period of 3 years prior to the application. And because of Mr. Benson's brain damage, he had received social benefits since 2009. So he could not support himself through employment. So Ms. Domina and Mr. Benson argued that the Danish rules constituted a barrier for persons with disabilities to enjoy the right to family life. They argued that there was a violation of Article 5 in the CRPD, which is the non-discrimination clause, and also Article 23 on the right to family life. And the committee concluded that the requirement of self-support under the Danish Aliens Act disproportionately affected Mr. Benson as a person with a disability, and it resulted in him being subject to indirect discrimination. The result was that they could not enjoy their family life on an equal basis with others. So they won the case, and since then, it just happened, the Danish government has reopened the case, and the couple has been granted family reunification, and Ms. Domina has received a residence permit in Denmark. The Danish government has not, however, acknowledged that discrimination took place under some weird explanation I'm not going to go into here. So right now, Mr. Mina and Mr. Benson are considering whether they should bring an action for damages against the Danish government. And I want to finish here by saying that this is an example of the importance of international monitoring mechanism. And I think this case illustrates that we need to, as much as we can, use these international mechanisms, because although this is only a case about 2 people in Denmark now having the opportunity to live together, it has created a discussion, and the rules are under consideration of being changed. So it's more than these 2 individuals. Thank you very much.
Thank you very much, Pia. Again, I think that reminds us of the themes coming up this morning around intersectionality and Freya's keynote around multiple oppressions, thinking about migration status, for example, disability and family life, all of the different ways in which family life can be hindered or impeded by the restrictions that we impose. So we're going to move straight on to our next panellist, Dr. Maeve O'Rourke from the Irish Centre for Human Rights here at NUIG Galway, and then we'll open up for Q&A at the end. Thank you. Maeve.
Thanks so much for the invitation to join you at this really important and inspiring gathering this week. My brief, or I suppose task for this morning or this afternoon, was to give maybe a broader perspective on what might be considered the rights that are relevant to family life, by reference to other people who have been marginalised, particularly in our Irish experience. So this afternoon I'm going to focus on Ireland's experience during the 20th century of widespread forced family separation. Part of this system was the institutionalisation of huge numbers of Irish people. In 1951, more than 1% of the Irish population was incarcerated, and only a tiny portion of this was in prison. So it was largely arbitrary detention in children's schools, in institutions for women who were considered morally wayward and who had to be kept outside of the community in order to further an idea of Ireland as a pure, morally pure and Catholic country. And another part of the system of forced family separation that operated in addition to the institutions was the system of adoption. Today in Ireland, and it's a very current issue, it's estimated that there are more than 100,000 people alive now who were adopted as a result of the system that operated in the 20th century. And those people, right this week in fact, are arguing very strongly for the right that they are still denied to know their own identity at birth. So I want to introduce to you something called the CLAN Project, which I set up with Claire McGettrick, who will be speaking to you on Wednesday. The CLAN Project we set up in 2015. It was an evidence gathering exercise. And the reason we established it was because in 2015, the Irish government set up a commission of investigation into mother and baby homes, which were institutions run by religious organisations, and there were also some similar institutions run by the state itself, which incarcerated girls and women who got pregnant outside marriage and arranged, in most cases, their separation from their children. We were concerned about the failure that we thought would be the case and has transpired to be the case of that commission to take a human rights-based approach. And we wanted to give people the opportunity to make witness statements and to keep their own copy of their witness statement when they wanted to give evidence to that commission. We also wanted the opportunity to then analyse those witness statements from a human rights perspective. And so the result was last October, the CLAN project report. And I should say that CLAN means family in Irish. So I can only give a really brief, I suppose, whistle-stop tour of this report this afternoon, but I really would recommend, if anybody's interested in these issues, going to that report. It's on the CLAN website. It's about 150 pages long. It contains lots of facts gathered from 79 witness statements, and then it contains detailed legal analysis. And I was assisted in making that legal analysis by about 30 barristers from the Bar of Ireland, and we had 69 solicitors from Hogan Lovells International law firm, their London office in particular, working with us. So the key factual findings of this report, which relates to the system of institutionalisation of women and girls who were pregnant outside marriage and the separation of unmarried families, was first of all that for much of the 20th century, state policy involved and approved the unlawful, as in arbitrary, detention of girls and women who became, or indeed were perceived to be at risk of becoming pregnant outside marriage. State policy supported and approved state involvement in the coerced separation of women and their children through a system of closed, secret adoption and also boarding out, which is what foster care used to be called. Part of this system was that it wasn't until 1973 that single women were entitled to any social welfare support from the state. So up until 1973, the only form of state funding for women who needed support was their incarceration and their separation from their children. And the state both cooperated with, but also crucially failed to adequately regulate and therefore inadequately supervised a range of state and non-state, religious and lay, Catholic or Protestant organisations in what they did. In terms of the treatment of women and children, there's definite evidence from the witness statements that we gathered that women and girls were incarcerated in a range of institutions, that they were subjected to forced labour right up until birth and indeed afterwards, and many women were kept in institutions for a number of years before their children were taken for adoption. Neglect in life and death seems to have been systematic in institutions. The institutions were not properly equipped, it would seem, to provide for maternity care. And we know from places like Tuam Mother and Baby Home, but it's certainly not the only place, that death rates seem to have been inordinate, and that many children were buried unmarked. Medical testing on children, both while they were alive in the form of vaccine trials and also after their death, in the form of the use of their remains for anatomical dissection in medical schools, is known to have occurred. The coercion was both through physical force in the sense of mothers being incarcerated and their children being taken from them in those circumstances, but also other forms of coercion. Their financial situation, of course, but the fact that state and society operated a culture of intense stigma and shaming of girls and women who were pregnant outside marriage. Before we had an Adoption Act in 1952, de facto adoptions were happening, and even after the 1952 Act came in, lots of adoptions that did not comply with its requirements were happening. We found that the experiences of children as they went on through life were impacted by the state's failures as well. There was serious lack of regulation of adoption societies, an inadequate social work system, inadequate regulation of the boarding out or foster care, complete silence and secrecy pervading both society and families in relation to adoption, lots of people growing up not knowing that they were adopted. And people did speak in their witness statements of feeling a loss of culture where they were adopted internationally. Finally, in terms of factual findings, we come to the treatment of women, their adult children, and their other family members, especially next of kin of people who've died in the present. There have been incomplete investigations. The Mother and Baby Homes Commission is not investigating all of the institutions. It is certainly not investigating the general system of adoption. There is no Garda police investigation ongoing, and people are very much precluded from going to the courts through a range of procedural barriers. And in fact, the Commission of Investigation, its underpinning legislation, says that none of its evidence can be used in civil or criminal proceedings. People have no statutory rights at present to their personal files. Then that means they have to rely on an ad hoc system for tracing family members, for getting their own information, and they did say in their witness statements that they're often treated with almost something verging on contempt or a sense of criminality when they go and try and find out what happened to them or what happened to their parents. Many graves are unmarked in the country, and there is a lack of national education and memorialisation. So we come to human rights. Happily, I suppose, in terms of helping with the ongoing campaigns for reparation, is the fact that lots of UN human rights committees have taken up these issues. And I think I just wanted to give you this list to show that what happened in terms of forced family separation does permeate out into lots of different treaties and lots of different articles in those treaties. You can see not just UN bodies, but also Council of Europe human rights bodies. And this is all due to, I suppose, lobbying and the bringing of evidence by civil society, grassroots organisations, and predominantly Adoption Rights Alliance, Justice for Magdalene's research. So we argue in the Clan report that in many cases what happened does actually fit the definition of enforced disappearance, which under the UN Declaration on the Protection of All Persons from Enforced Disappearance is essentially the abduction or detention of a person with the state's involvement, followed by a refusal to disclose their fate or whereabouts, leaving them outside of the protection of the law. Then, of course, discrimination and dignity violations. We have argued, and as you've seen, the UN Committee Against Torture has taken up this issue, that what happened through the institutionalisation and forced separation of mothers and their children does amount to degrading treatment in the sense that it was profoundly humiliating, cruel or inhuman treatment in the sense that it caused severe suffering. And indeed, we do argue that we feel that in some cases, if not many, forced adoptions could be argued to amount to torture in the sense that they were performed with discrimination in mind, with a discriminatory purpose in the sense that it was only applied to women and families who were unmarried, and that it intentionally caused great suffering. I've written here that, and I think it's important, I suppose, to just reflect on the fact that forms of so-called vulnerability are important to the minimum threshold of severity analysis when it comes to evaluating when certain treatment amounts to torture or cruel, inhuman or degrading treatment. So in the Clan report submissions, and of course in submissions to UN human rights bodies, we would have drawn attention to the fact that people were detained. That is a form of vulnerability that the human rights bodies frequently focus on when assessing the minimum threshold, whether treatment has reached the minimum threshold of severity. Also, dependence on the state, or total dependence on carers or people in charge of you in an institution. Children, of course, are accepted by the human rights treaty bodies to be vulnerable, and that means that the treaty bodies sensitise their assessment of whether torture or cruel, inhuman or degrading treatment have happened. And the same goes for victims of sexual assault or rape. We argue that arbitrary detention occurred. There was no legal basis for detentions. And apart from that, when people were detained, it was frequently unknown to them how long they would be detained. There wasn't adequate monitoring of their detention, opportunities for them to complain. slavery, servitude or forced labour, we argue that the treaties that prohibited these acts were violated by Ireland, both through its involvement with institutions and also its failure to regulate them. Some of the institutions involved in this system, notably the Magdalen laundries, where sometimes women who had had children a second time were indefinitely detained, actually washed a whole range of state laundry without paying wages, meaning that the state actually benefited from the labour that those women were performing for free, in the sense that they paid less because all of their contracts were tendered for. Violations of the right to life at the time of these institutions' operation, in the sense that there are lots of reports showing that the state knew that conditions were not adequate and failed to act, but also now in the sense that investigations are inadequate and there are still many unmarked graves. And I suppose for the purposes of today, the most important violations of the right to respect for private and family life. And we argue that violations occurred through, of course, the forced or otherwise illegal separations, the denial frequently in these institutions of an opportunity to care for and bond with your own child. Women were frequently performing forced labour and in their witness statements spoke of only having an hour a day to see their child, of feeding other women's children, not their own, in the institutions. The humiliating manner in which women and girls were forced to give birth, non-consensual medical testing, a failure to mark burial places, and ongoing a refusal to provide personal information to people who suffered in this system and also the family members of the deceased. Of course, today a huge issue, as I mentioned at the very beginning, is the ongoing denial of the right to know your own identity as a person who was adopted or otherwise informally placed as a child. And we've argued in the Clan Report there are continuing denials today of rights to, I've got here rights to an investigation, access to justice and redress, and that all falls within the right to an effective remedy under the European Convention on Human Rights, also the UN principles on reparation for gross violations of human rights, and then of course there are certain treaties, for example the UN Convention Against Torture, which outline these particular remedies. But we do argue in the Clan Report that these remedies apply to the system as a whole and to the rights violations that I've outlined as a whole. And then, relevant, I suppose, to these issues, because they are so-called historical, are some key procedural issues, I suppose, as well as substantive. The issue of state responsibility is an important one, and it's one that we deal with in the Clan Report in quite considerable detail. Of course, a state can be responsible where it has directly perpetrated human rights violations, and in the case of the mother and baby homes, county homes, adoption system, it directly incarcerated girls and women frequently. The police were involved in returning escapees. It ran a number of institutions. It also funded a number of institutions, and also a number of voluntary organisations had powers that would today bring those institutions within the definition of a public body under European law. But also the state is responsible for human rights violations when it fails to exercise due diligence. There are various ways of describing this obligation, but for example, where it knows or ought to know that human rights violations are happening and it fails to act. And in the Clan Report we go through how these failures manifested and how the state did know at the time what was happening and failed to properly monitor. And I suppose the failure of due diligence also is key to an argument that we make in relation to reparation for these abuses. An important part of the comprehensive notion of reparation, as the UN Committee Against Torture has described it, and also as it's described in the UN Principles for Reparation for Gross Human Rights Violations, is the notion of guarantees of non-repetition. And structural and institutional changes as part of reparation for the past acting to make sure that these things never happen again. And we would argue that in Ireland today we have a major deficit in terms of the regulation, the adequate inspection and the adequate monitoring of private or so-called non-state entities that the state outsources its social services obligations to. The timing of complaints has been a huge issue in relation to all of Ireland's historical abuses, at least in my experience as a practicing lawyer when advising victims and survivors, and also I suppose generally in the public and political discourse, because it's always something that the state will rely on. Limitation periods, are they allowed? We've discussed that in the Clan report, and there's some very interesting jurisprudence, particularly from the Inter-American Court of Human Rights and from the European Court of Human Rights in the realm of torture and inhuman and degrading treatment, speaking about, again, the concept of vulnerability, talking about that, saying that vulnerability arises where the state has been involved in your abuse, has failed to investigate it, and some interesting cases where people have been found to have been at no fault, I suppose, by waiting even decades before they complain. And those human rights bodies finding that they can't have been expected to have complained when there had been no state investigation or when nobody else had successfully gone to the courts. So that's worth looking up if people are coming across similar issues. Of course, you have continuing situations of rights violations where there can be no argument that the violation has finished and that you have delayed too much before complaining, and we argue that they arise, of course, where there's been enforced disappearance, because by its nature that is a continuing rights violation. It continues as long as the state refuses to disclose the fate or whereabouts of a person. But there's interesting jurisprudence too under Article 8 of the European Convention on Human Rights regarding forced separation of the case of Jovanovic in particular, of a mother and her child in the 1980s, her case only being brought to the European Court's attention, I think, in 2006, and that being found to be a continuing situation of an ongoing violation. So not just an ongoing procedural violation, but actually an ongoing substantive violation. And of course, we have continuing procedural violations, and this has been relevant in the Irish case where, for example, Ireland has only ratified conventions after abuse has happened, and in particular the right to an investigation and the right to access to justice have been found to continue in relation to abuse that has happened before ratification. Those obligations continue afterwards. And I'll finish there, but thank you very much.